Welcome to another session of Mehta and Mehta. And of course, now another series, last series was related party transaction. And it is welcomed and very well received by all of you. We are getting a lot of compliments. People are telling that if anything we want to know or any emergency come in RPT, we open Mehta and Mehta webinar, listen to that and we get the solution. They all appreciate this knowledge sharing. And Sudhakar, your session was specifically yours. Everyone appreciate. And in the same way, looking at that, we started another series on insider trading. Because any professional, either CA, CS, independent director, corporate, they all are worried with these two things: related party, insider trading. Because many times the corporates do not want to do this or do not want to carry out any non-compliance or breach or default. But due to certain interpretation, due to certain misunderstanding, due to lack of proper communication or lack of proper system or audit, there is chances and the non-compliance happen, and it has a very big implication, not only financially but more on the reputation and the governance issue creates. In view of this, the importance of this topic, we have started this series on insider trading. And this time, for a change, we are having our own panelist, and it will be discussion on the first topic, on the first topic or title on this insider training webinar on an insight into important definitions, regulations 3 and 4 of SEBI PIT regulation. And we will start with the definition, because unless we know the definition, we will not understand what is insider trading compliance. And we have presented with us our own partner, and welcome here. And I'll request Sudhakar to start the session with a few words, then Bala, and then session can start. Thanks. Over to Sudhakar.
Yeah. Thank you, Dipti, and good morning, friends. As Dipti has rightly mentioned that the encouragement what we have received from the feedback for the last 2 series of webinars, it has motivated us to come with another webinar series on the insider trading regulations. In fact, I also take this opportunity to tell every one of you that in future also, if you want any particular topics of importance to the fraternity, if you want this kind of a webinar series we have to organize, please give your feedback to us, and we will certainly work upon that. Because the purpose of these webinars is not like the conferences or webinars to have just a 2 hours discussion. We want to take a deep dive into each and every aspect of the important aspects to the fraternity. Wherever, the objective is to have a mutual learning. It is not like that as if we have everything to answer your questions or queries. At the same point of time, even in this insider trading regulations also, if we have any queries and all, instead of putting in these chat boxes, you can write in advance also to us, so that we will come prepared and we will address those issues. Several times it so happens that because of the time constraint, we were not able to answer all the questions. And similarly, some lengthy questions used to be there, which we are not able to understand because we were hesitant in giving the answers to those type of questions. So what I request all of you is, if you have any perennial issues, please do write to us. We will understand that and then we will answer. If need be, if the FAQs are more, maybe we can exclusively dedicate one webinar for that particular purpose also. At the same point of now, as far as today's topic is concerned, when we have conceptualized in this webinar, because we have seen several times the compliance officer, obviously it is the company secretary, who has to deal with such a complex subject. Whether you are a company secretary of 3 decades of experience or 3 years of experience, it is immaterial. You are the compliance officer. and you have to ensure the compliances as far as the insider trading regulations are concerned. I always used to say that insider trading regulations is like playing with fire. And one need to be very, very careful while handling the fire, and the same amount of exercise is to also takes place as far as handling the prohibition of insider trading regulations are concerned. To a large extent, the non-compliance is because of lack of awareness across the organization, because this is such a subject, it is not confined either to the secretarial department or finance and accounts department. It is confined to the across the organization that awareness is to be created. And sometimes it may so happen the company secretary in the concerned organization may not be a senior person. The amount of attention what is required for the compliances may not be given also. That's why it is always advisable to ensure that the compliance officer to create a kind of awareness across the organization as far as the insider trading regulations are concerned. And also at the same point of time, the compliance officers have to take, whether the time is available or not available, but you have to have in-depth knowledge, because this topic is such a topic like your last webinar series, related party transactions. By barely scratching the surface, you will not be able to comply with the subject. You have to have a thorough knowledge. You have to take a deep dive into this. If you see the PIT regulations, it is a very small act, unlike other security laws. Hardly 9 regulations are there and 3 schedules are there. But each and every word of the insider trading regulations have its own nuances. That's why we have dedicated this particular definitions as well as regulation 3 and 4 for today's topic. As I have mentioned that, because understanding the complexities of the subject, we have to have thorough knowledge and deep understanding, for which the intense diligence, according to me, is required as far as the company secretaries are concerned. And similarly, any trading in the securities of the company based on the unpublished price sensitive information is illegal and unethical. This particular words have to go across the organization. Any kind of trading based on the UPSI is illegal. The moment anything illegal means, it is going to attract criminal penal consequences. Hence, one should be very careful. Whoever is the person handling the unpublished price sensitive information, he is to be told the consequences of conscious or unconscious leakage of such information. And any kind of non-compliance in the organization or any kind of leakage of the UPSI is concerned, it is the compliance officer who is there on the radar of the regulator as the first line of defense, you can say. So he has to shoulder onerous responsibilities to ensure as far as the applicable compliances are concerned. And not only his understanding of the regulations is important, but he has to also spread that knowledge across the organization. In fact, I strongly advise the compliance officers they have to ensure that this is not a one-time what's called as knowledge dissemination as far as PIT regulations is concerned. It should be a constant and consistent exercise, especially in case of designated persons, because sometimes the people have a wrong notion that only the designated persons are concerned with the PIT regulations, others are not concerned. People are not aware of the word who is the insider. It is very, very important. Under the PIT regulations, it is not only the designated person who is responsible, who will be held responsible if anything goes wrong, but anybody and everybody inside or outside the organization, even an office boy, if he is a party to the leakage of insider information, he will be held responsible for that. That's why several times I used to caution that at the time of the board meetings, if you are discussing any information which is having a kind of an impact on your price of the security in the market, you should ensure the people who are inside the boardroom at that particular point of time, God forbids any information is leaked. Those are the people who have to, when you start the audit trial, it is to start from them. Maybe you can restrict even the presence of a person who is serving the tea. You can say for half an hour, nobody should be allowed inside the boardroom, or nobody should allow to go outside the boardroom. So the compliance officer should take liberties as far as the protection of the UPSI is concerned. I will give a pause here, and then while the presentation goes, wherever I have to give some kind of a value addition with my experience, I will do that. So before I invite Kanchan to make a presentation, Bala sir, you kindly give your intro remarks. Thank you.
Good morning to all of you. As Dipti and Sudhakar has actually said, the regulations are very, very important regulations. It is not only in India, it is even across the world. But in India, it has become in a legalistic way, in a very big way from the year 1992 onwards. And thereafter, there has been many issues which have cropped up, many things which have happened. And the regulator has kept on amending the regulations. Lastly, 2018, they amended the regulations to a greater extent, and more stringent provision has been actually brought in. But as a company secretary, we love to be very, very thorough in our understanding clearly. Because Sudhakar puts it, insider, who's an insider? Insider doesn't go by the designation or seniority or something like that. If the finance department is there, even the smallest person who is working in the finance or lower level clerk, he will be considered to be an insider because he has concern with the facts and figures and the publication of the information. He is well aware of that. That is the thing. Sudhakar has given a very nice example. When a discussion is taking place, some P-boy is coming inside, he is at least understanding literate enough that he can go out and leak out the information. Such thing has happened in the past. To be very frank with you, one of the cases which I came across, members in a particular companies, this is actually came up under the scrutiny of the regulator, and it was popularly known as the congressional scam. So what they have done is they actually found out whether it amounts to insider information. They have used it because of the situation, and they have done it. It was held so. To such an extent, it has got the impact actually insider. So today's our topic is restricted only to understanding the main definition. I think according to Section 3 and Section 4 of these regulations. First of all, when we talk insider, who's the insider? Who are all covered insider? Second thing is insider information. It is spread into two words. One is the information, one is insider. All the information is not insider information. So what we actually mean by the insider information, and by using the insider information, if we cause the market abuse, undue gains, either for ourselves or our relative or friends or whatever it is, directly, indirectly, all the things actually unethical, very category. So really speaking, today we will understand the important definitions, because we'll travel down for the other seminar. We will get the intricacies of the whole regulations. We will be rich enough after the end of the fifth seminar. And Kanchan will take us today the various definitions. She will make us understand what is the important, what is the, I think she will also give some of the examples when we are talking about it. I think compliance officer has got a lot of role to play, because compliance officer has to actually institute a system in a company. Because what happens is there is nothing called a regular reporting to them, to the stock exchange, the ongoing business or something like that. If something goes wrong, you are in a problem. So nothing goes wrong, you need to have a system in place. Company has to evaluate system in place, company has to have a code in the place. And the identification of the insider is very, very important. In many organizations, there's a system in place. Sudhakar also will agree with me. At the time of appointment itself, the person is actually identified which department is joining, what is the important, whether he is actually used to get the insider information or price sensitive information, etc., and other things, and all this thing is identified. Along with the appointment itself, he has been actually asked to sign another letter, a letter of confidential letter, which is actually abiding by the insider regulation, which is actually formulated by the company. That starts from there. As Sudhakar puts it very clearly, the compliance officer has to got a role to play right from the time of the appointment of the person, identifying the person, and educating the people, and very importantly, making the awareness across the organization. Doing something in this sort of the nature is totally unethical, punishable by law. That sort of the awareness has got to be created. That is something everybody should be aware. It is not only particular person, it is restricted only one department or compliance officer or company secretary. It is not like that. So that has got to be there. Another important thing is there have been regulations undergoing a changes from time to time. Company secretary has obviously get updated himself, and he has to also get updated the board, etc. If there is any action arising out of those updation, etc., company needs to modify. Those things also he has to actually put in place. These are all the nitty-gritties which are there. So with this, I think I'll ask Kanchan to start the presentation. We will understand the important definitions today. Any procedural related things or anything structural related database, etc., these are all going to be discussed in the future seminar. So your question could be restricted only to section 3, section 4, definition part of it today. I'll request participants, because we'll have 4 more sessions to write the various other queries. Let us restrict our queries only pertaining to what is being discussed today. That is my humble request to all of you. Over to Kanchan, please.
Thank you so much, sir. A very good morning to panelists and all the viewers. So with that brief introduction from our panelists, I think I would get straight away into our presentation. I would like to keep my presentation brief so that there is more deliberation from the panelists end. And so let me just start. Yes, sir. So let me first start with a little introduction. Why do we have these regulations, and what is the history? What has the history been towards promulgation of these regulations? So the flow of my presentation is going to be this way. We get into the introduction a little, and then the prominent terms, as Sudhakar sir and Bala sir have put in, we will get into the definitions and also the common understanding of these terms. And thereafter, we get into Regulation 3 and Regulation 4. And then we would discuss a few case laws pertaining to these regulations. So let me just start now. SEBI had promulgated the prohibition of insider trading regulations in 1992. And later they were amended in 2002. And as a part of the periodic review process, they were consequently replaced with SEBI prohibition of insider trading regulations, PIT regulations 2015, which came into force from 15th of May 2015. In 2018, SEBI introduced certain amendments to PIT regulations pursuant to the recommendations made by Vishwanathan Committee, which is effective as we are all going through them from 1st of April 2019. The existence of a fair, vibrant, and efficient securities market is one of the essential ingredients for the economic growth of a country. So further, fair market can be ensured by prohibiting, preventing, detecting, and punishing such market conduct which leads to market abuse. Let us understand what we really mean by market abuse. It's generally understood to include market manipulation and insider trading as such an activity that erodes investor confidence and impairs economic growth. So before getting into the definitions, let us fairly understand in a common parlance what we exactly mean by insider trading. It is the trading of a company's securities by individuals with access to confidential or material non-public information about the company. It results in breach of a fiduciary duty or other relationship of trust and confidence It gives scope for conflicts, reduces investor confidence, and causes market abuse. It's not only illegal, but also unethical. So just common understanding for all of us, insider trading violations, it may also include tipping such information. Let's say a CEO, maybe who goes for a haircut, he may accidentally discuss the quarterly results of his company while having a haircut at his salon. Would that actually tantamount to sharing of information, confidential information? Yes. Or we may have shared such kind of confidential information with our friends over a part of our conversation, would also make this a part of the insider trading. So we have seen Harshad Mehta in the past used this position as a stockbroker to manipulate the stock prices of various companies by using the insider information.
Discussing the information is okay, as you rightly said.
Yes, sir.
But the thing is, the friend who actually with whom he discussed the information, he makes use of that information,
Right.
and he makes the undue gain or avoid undue loss, etc., and all the things. Then ultimately that amounts to actually unethical, illegal activities. Yeah.
Yes, sir. So then, why do we need these regulations? So just to briefly point out a few things. For the existence of a fair, vibrant, and efficient securities market, and then to instill the confidence, trust, and integrity in the securities market. And we can ensure this by prohibiting, preventing, detecting, and punishing such market conduct which leads to market abuse. So what is insider trading? So the term insider trading, it has not been defined anywhere. However, insider trading refers to trading or dealing in the securities of a company by persons who are in the management of the company or who have close proximity to them on the basis of knowledge of unpublished or undisclosed price-sensitive information, UPSI. So the term insider can be broken down to understand in two things: who's a connected person and any person in possession or having access to UPSI. So who exactly is an insider? An insider means any person who is either a connected person or anyone having access to UPSI. So it is clear that anyone who owns or has access to UPSI would be considered an insider, regardless of how such person came in possession of such information. So then what is trading? It means and includes subscribing, redeeming, switching, buying, selling, dealing, or agreeing to subscribe, redeem, switch, buy, sell, deal in any securities, and trade shall be construed as dealing in shares. So I'd request our panelists to throw some light on the definition of insider and in trading both. And we'd also like to understand from you, does gifting of shares also fall under the definition of trading then?
Okay. As you rightly said, as far as the insider is concerned, insider is as such not defined under the Companies Act. But yes, any person who is having access to the information of the UPSI and who is having that information with him, he will be considered as an insider. As Bala sir has mentioned, by merely having the information is not unethical or illegal. But when you use that information or when you share that information, you will be held liable as an insider. As I told you that a person who is serving the tea in the boardroom, even if he is an illiterate person, but still he can understand, suppose at the point of time when he is serving the tea, the CFO or the CEO have mentioned that this year we have a bumper turnover, the highest ever profits, and we are going to declare a huge dividend. This kind of statements, if they made in the boardroom, and he heard this information, and if he shared this information without even knowing what exactly he is giving it to somebody else, and that somebody, if he deals in the stock market based on this information, even that office boy who served the tea can be held responsible as an insider who shared that information. As I told in the beginning itself, playing this insider information is like playing with a fire. Whether you know whether it will harm you or not, but it will certainly burn your hands when you're touching that fire. Same is the case with insider information. In fact, I read somewhere, that abroad this has happened. A CEO of a company was talking over the phone about the company, the strategy, what they are going to make in the next 1 month, and how the company is going to progress. The driver who was an illiterate virtually, he overheard that. And at the dining table, he shared that information with his son, because he took pride in for working such a company, and his company is going to do wonders. And his son was working with a mutual fund company, and he shared that he knows the importance of such information, and he shared it with his colleagues, and they made a killing. That amounts to insider trading information, because that CEO unconsciously he has leaked that information, and he will be held responsible. This is how an insider trading and the leakage of UPSI is going to be determined. Whenever any kind of leakage happens, when the audit trail is go back to the person from where it has originated, and who will be held responsible. If it is consciously, how much what's called as liable he will be made, and how much penal provisions will be imposed. It all depends upon the thing. That is a different thing. But certainly everybody will be held responsible as far as the insider is concerned. Before I come to trading, Bala sir, if you want to comment about the insider.
Yeah, when you talk about the insider, it is not always insider necessarily has to be an employee of the company, or he is a working person in a company. As she puts it in the beginning, connected person. Connected person means the person who temporarily have an assignment with the company. For example, even the statutory auditors who are actually auditing the financial informations for a particular company, at that particular point of time, he has all the information about the company's turnover, company's profitability, everything. He has got the information. And similarly, if the company is working with some merger and amalgamation project or something like that, normally the company employs various people, including a consultant, legal expert, or even the merchant bankers, etc. All these people, they are actually privileged to that information. This information, unless until it is actually finalized, it is formally, it is not made public, till then the information remains actually confidential. So anybody whosoever comes to know about this information, either by virtue of their being an employee, or by virtue of getting connected, or by virtue of whatever the capacity they are associated with the company regarding to that project, if they get the information, as you rightly say, passing on the information to somebody. See what happens in a group. There are about 5-6 people are there. They have to exchange the information. Even this confidential information is to be exchanged between them, because it is necessary for them to work together. In which case, exchanging that information per se is not illegal. But exchanging that information, if it is passed on to his friends, relatives, or somebody, then using that information and making undue gains, or rather avoiding a greater loss, etc., whatever way it takes, then that itself is illegal. So insider can be anybody who should be a connected person, either temporarily or employee or permanently, whatever it is. That is the way we'll have to look in. We'll have to identify who's an actually insider at that particular time. as I said earlier also, insider need not be a status quo based as a seniority or management level, etc. and all this thing, as he has given a very good example, the tea boy. Anybody who comes to know, either accidentally or in the course of the working or whatever it is, that person become an insider irrespective of his status. Yeah.
Yeah. Now, as far as the trading is concerned, it is when you are having the UPSI with you, that is unpublished price sensitive information with you, you should not trade in the securities of the company. And the trading definition has been expanded in the, if I am not wrong, in the 2019 amendment. As Kanchan has mentioned, that trading also includes, it is not only buying, selling, subscribing or redeeming, blah, blah, blah and all, but also dealing. That word dealing is very, very important. Exactly, this word dealing is not defined as such, if I am not wrong, in the insider trading, this PIT regulations. But if you see the guidance note of ICSI, there we have clearly made a distinction between the trading and dealing. So what is trading? We can say that the action of your subscribing, redeeming, buying, selling of the securities where direct consideration is involved. That means you are making the payment or you are receiving the payment. That consideration, direct consideration is involved. That we may call it as a trading. Other than that, suppose the activities like pledging, gifting, transmission of securities, here there is no direct involvement of any consideration is not there. You are not making any payment when you are pledging the shares. And when you are depledging, you are not getting anything. Similarly, when you are gifting, you are not getting anything. Similarly, in case of transmission, there is nothing, no direct consideration is there. So these are all primarily that we could call it as dealing. In fact, when we were preparing the guidance note, I was privileged to be a party of that. And that point of time, this question has come up whether creation of pledge, invocation of pledge, revocation of pledge, does they amount to trading? The answer is yes. Whenever you create a pledge or wherever the pledge is invoked by the lender, or when the pledge is revoked, all the times it amounts to dealing in the securities of the company. Is transmission of shares, is it amounts to dealing in securities? Again, answer is yes. The norms in relating to disclosure requirements, etc., will be applicable. But the only thing is that in case of transmission of securities, the pre-clearance or the contra trade restrictions will not be applicable. As far as the same is the case with the gifting of securities also, no doubt about it, that is also amounts to trading. And whenever you give a gift, that point of time, because it is also amounts to trading, and whatever the reporting requirements of there under regulation 7 or 8, those compliances are to be ensured. Yes, Kanchan, go ahead further.
Yes, sir.
And one more thing is there I wanted to add here. Mr. Sudhakar actually mentioned about the guidance note. Our institute has been actually bringing out exorbitant guidance note in each of the topic section. Even the related party transaction, when we are discussing, we were talking about the guidance notes. Nowadays, what is happening in the recent past, I have been actually seeing it. The regulators, especially ROC, RD, these people, they not only apply their mind going to only the provisions of the Companies Act or Security Exchange Board of India's regulations. They also refer the guidance notes. They also refer the checklist. They pick up their points while actually making the adjudications order. Very recently, one of the classic order has been actually passed by Ahmedabad ROC. It is relating to Sun Pharma case on the related party transactions. Really speaking, in this particular case, it is a very, very speaking order issued by the Registrar of Companies. He elaborately referred the guidance note issued by the Institute of Company Secretaries on related party transaction, and as well as the checklist. he elaborately discussed what is the duties and responsibility of the secretarial auditor. In this particular case, the secretarial auditor was actually penalized to the tune of 1.5 lakh rupees for not disclosing material related party transaction in this particular company where he issued the secretarial audit report. So it is really a very eye-catching or even eye-opening case, which all the practicing company secretaries need to go through because it's very important from here. So the point I am making is we not only have to go by the standard issued by the companies, but we also need to go into the various guidance note issued by our institute, which has been extremely done applying the experts' mind, which is very helpful for our discharging the functions. Go ahead, Kanchan.
Yes. So let us now understand what do we mean by unpublished. It means information which is not published by the company or its agent, and it's not specific in nature and is not generally available in public domain. So what information are we referring to? The information talked about is price sensitive information. It is unpublished and is likely to have an impact on the securities of the company, affecting its price in the marketplace. I'd like our panelists to
go ahead, Kanchan. I think after that, when that upsay comes, your slide of unpublished price sensitivity, that we will discuss. Otherwise, you will not proceed further.
Right.
Yeah, you please explain this.
Yes. So unpublished price sensitive information means any information directly or indirectly related to the company or its securities that is not generally available to the public, and upon becoming generally available, it is likely to materially affect the price of the securities and shall ordinarily, including but not restricted to, information relating to the following: financial results of the company, dividends of the company, change in capital structure, any merger, demerger, acquisition, delisting, disposal, and expansion of the business, or any change in key managerial personnel.
So this is the most important in the entire PIT regulations. If you see, it goes around this unpublished price sensitive information. So what is primarily this unpublished price sensitive information? Every one of us know that because in the header itself, it is there unpublished. Unpublished means it is not the information not available in the public domain. Unpublished information means it is a restricted information. And actually, when you run an organization, so much of information is available. Whenever you make any kind of activity in the organization, that is an information only. But that unpublished information, which is not available in the public domain, if it is price sensitive. Now, what is a price sensitive? Price sensitive is if it is when, in case that information comes to the public domain, is it going to cause any kind of impact on your price of your securities? That sometimes people are in a wrong notion when we talk about impact on the price of your securities. People think that the price will jack up on the higher side. When we say price sensitive or the impact on the price, share price means not necessarily the share price has to go up. It may also go down. If that information is coming to the public domain, your 800 rupees share may crash to 700, 600, 500, depending upon that, whatever the checks and balances of the exchanges are there. So that may be on the higher side, maybe on the lower side. So by the time that information comes to the public knowledge, by the time the information is published, the persons who are having that access to that unpublished price sensitive information, if they act upon that, they will make a killing at the cost of the other people who don't have access to such information. That's why it is called as illegal as well as unethical, and the consequences will be very, very severe. So that is the one of the reasons why we say that during the time this unpublished price sensitive information is generated or germinated, that point of time, the notional trading window is to be closed. And it is the responsibility of the compliance officer to decide upon when the window is to be closed and which information is price sensitive information. that also, this is only whatever here the Kanchan has given, that is only indicative result, indicative information. In addition to this, there is any information which is going to cause an impact on the market price that is going to be upsee. So it is for the compliance officer. He has to determine that, and he has to ensure that the window is closed appropriately. As far as the quarterly results is concerned, no doubt about it, from the end of the first day of the end of the quarter, till the 48 hours after that information is published, the window is bound to be closed. As far as other issues are concerned, it is the company secretary who has to determine that. Yeah.
The only thing what is coming out here is two things: insider trading and insider information. Having an insider information per se is not illegal or unethical. You can have the insider information if you are discussing with somebody within the group, which is required as a job based, etc., which is necessary, that is there. It is in many companies, when they are doing some sort of the project, they create a separate, a group. This information is available only to this particular group only. And there is a guidance are issued actually. They should not share this information outside the group and other thing. And it will remain within the group only. Still such time, the company take the final call on that. That is the way it actually works. So Sudhakar puts it very correctly. By using this insider information, the trading takes place. Both the ways. Either he is making a profit, or as he puts, the share price is actually coming down. That means he is actually avoiding the possible loss by using his information.
So designated person. Who is a designated person? It means all the employees of the company who have access to unpublished price sensitive information, they are identified as designated employee person. And designated persons include promoters, directors, KMPs, auditors, all employees and support staff of the company.
Only one line I have to add here is again that who is a designated person. It is to be determined by the company and the compliance officer. The compliance officer, in consultation with his colleague, with the CFO or CEO, whoever it is, they have to determine that who are the designated persons. Designated persons in an organization primarily is all those people who have reasonably to have access to the unpublished price sensitive information. Because it may so happen that the designated employee, in general, he is having access to the information, but sometimes he may not even not having the access to certain information of the company. So you have to see at a macro level who are all the people who will be having access to the price sensitive information, and you have to determine them that they are the designated persons. And whatever the compliances they have to make and all these things, it is the responsibility of the company secretary to communicate with them from time to time with regard to the compliances, with regard to the restrictions as far as the trading of securities are concerned, not only of him, but also of his relatives. That's why at the time of joining of a person, if by virtue of his designation, if he is going to be determined as a designated employee, at that point of time itself, you have to get the whatever the necessary information is there, and he is to be informed that he is a designated person, and whatever the restrictions are there, those are going to be applicable to him. Yes.
You are right, Mr. Sudhakar. Yeah, at the time of the employment only, he has to be identified whether he is actually a person who is going to be inside a person or not inside the person, who is the designated person. Then normally what happens is, he normally spends at least half a day with the company secretary, the compliance officer, whoever the person is there, so that he makes him to understand what is the insider trading, what is the insider regulation, what is the insider code, what is the role, what is the responsibility. Insider code, along with the terms and conditions, etc., is actually given a copy to them. He has been asked to read, and he has been asked to sign it, that he has actually received it, he has understood it, and he will abide by the insider code, which is actually formulated by the company. That is done at the time of the appointment itself. Yeah.
Yes, sir. Can we move ahead, sir?
Yeah.
Yeah.
Go ahead.
Okay. So We have been right from the start of our webinar, we have been talking about a compliance officer. So let us now understand who's a compliance officer. It means any senior officer designated so and reporting to the board of directors or head of the organization in case the board is not there, who is financially literate and is capable of appreciating the requirements for legal and regulatory compliance, and who shall be responsible for compliance of policies, procedures, maintenance of records, monitoring adherence to the rules for the preservation of unpublished price-sensitive information, monitoring of trades, and the implementation of the code specified in these regulations under the overall supervision of the board of directors of the listed company or the head of organization, as the case may be. So here, financially literate shall mean a person who has the ability to read and understand the basic financial statements, balance sheet, profit and loss, and statement of cash flows.
See here, unlike listing regulations, the compliance officer need not be a qualified company secretary. If you see in case of listing regulations, it is very clearly mentioned that he should be the company secretary of the company. He should be he should be a qualified secretary who should be the compliance officer as far as the listing regulations are concerned. Unlike that, in case of bid regulations, it is not so. Only thing what it says is that he should be financially literate. He should be fairly a senior person, and who should be capable of appreciating the requirements. So obviously, if you see the requirements, it is the company secretary who should be the compliance officer of the company. He should be at least a qualified company secretary, maybe a chartered accountant who got fair amount of knowledge and all. But 99.99% of the cases, it is always the compliance officer is the company secretary of the company. Now the question is, can a company have two compliance officers? Answer is yes, definitely they can have a compliance officer. But when you declare it that these are the compliance officers, you may internally, you can what's called as demarcate the responsibilities of the compliance officer. But as far as the regulator is concerned, you cannot tell the regulator, but that look, Mr. A and B are the compliance officers. A's responsibility is this, B's responsibility is this. You hold them responsible accordingly. That is not the way it will happen. As far as if I am the regulator, I am going to take both A and B as the compliance officer and they will be held responsible. But no doubt about it, internally, if they have been some kind of a divided responsibilities, to that extent, a kind of a leeway may be given, but he will not be absolutely absolved from that non-compliances because my area is this, your area is that, not like that. Within the organization, yes, whenever the organization is going to take any kind of action for any kind of non-compliances, as per the demarcated responsibilities, they may initiate the action accordingly. Yeah.
So I have a query here. If we have more than one compliance officer, and when there is a decision that need to be taken, if the other person is not available, can one of the compliance officers go ahead and take a decision? So then what would be the liability for all the compliance officers in that case?
See, as far as I told you that as far as the regulator is concerned, both are having the same standing. As far that only the demarcation of responsibilities are within the organization. I am sure that whenever there are two compliance officers are there, certainly the company will say that in the absence of the other person, this second person has to take over the charge and has to ensure the compliances are concerned. Say, for example, pre-clearances are to be given, window is to be closed, contract trade restrictions are to be permitted. And one compliance officer, for whatever the reasons, he is sick and he is not attending the office for the last 3 months. Can the other compliance officer say, "But this is not my responsibility, this is not my demarcated role"? No, he cannot. So to some extent, considering if there is a large size organization is there, but very rarely I find that there are two compliance officers in the organization. To a large extent, this question is hypothetical, but still I have answered that. And if at all anything is there, and as I told you, companies, as far as they are concerned, if they are appointing two people, considering this kind of nuances only, they will do it. And if one is not there, the second has to take over the charge and then has to ensure the compliances. Okay.
You're absolutely right, Sudhakar, because if there are more than two compliance officer company, that will hold good only for the purpose of internally within the organization, identifying the things, etc. But as far as the regulator is concerned, both of them are definitely responsible. One cannot escape saying that it is not my area, that is not my area. When you are designated compliance officer, you are a compliance officer for all the laws which are applicable under the regulation. That is it. Yeah.
Right.
Ashwini is, I think, putting in this thing. There are some questions in the chat box.
I just have a personal query here. Can the compliance officer position be vacant in case of PIT regulations?
See, because if the compliance officer position is vacant, but you should have some kind of an alternate arrangement in the meantime. Okay. So there should be somebody who has to discharge the responsibilities. Yes, compliance. Suppose when the company secretary itself, when the KMP position can be vacant, obviously the company compliance officer position will, by default, it will become vacant. But only thing is that when the company secretary is not there, whoever is the person taking over the charge and running the company till the time the position is replaced, and same is the case with compliance officer. It is not like that 24/7, there should be somebody in the position. Nowhere it is, the requirement is there like that.
Ashwini, sometimes
Okay,
If I am not wrong, only the position of auditor is there like that. That position cannot be vacant. That's why, except that, rest of the things are not a problem.
Ashwini, in case of the company secretary resigns, they take some time to recruit the company secretary. Of course, the law gives the time for a period of 6 month period to fill over the vacancy, etc. But during this period, board meeting has to be conducted. So can we escape saying that, company secretary is not there, we are not conducting the board meeting? No, because somebody has to take a responsibility. Somebody has to conduct the board meeting, somebody to discharge the compliances, that is to be there. So naturally, alternative arrangement has got to be in place in the absence of the company secretary. We cannot simply get on saying there is no company secretary.
Something like an interim position, you have to.
Yeah. That is the thing. Go ahead, Kanchan.
Yes. So let us briefly understand the role of compliance officer.
I have to make one submission to the participants. Don't send me any WhatsApp queries to my personal WhatsApp messages. Please put it in the chat box only. I'm not going to answer any WhatsApp questions here. Thank you.
So the role of compliance officer is he is required to prepare a Chinese wall framework, receive the initial disclosures and continual disclosures, ensure that the computer data is adequately secured, frame a code of internal procedures and conduct in line with the model code specified, and then keep records of the periods, as in the closing period, trading window to be closed, and to frame and monitor adherences to rules for the preservation of price sensitive information. So all of the terms that appear here, we would be taking up all of these in detailed discussion in our future presentations. This is just to briefly understand here what exactly is the role of compliance officer. If panelists would like to throw some light on how important is this position.
So this we have done already, I think. Go ahead, Kanchan.
Yes, sir. Yeah. So let us understand who's a connected person. So any person who is associated with the company directly or indirectly, or has been associated with the company during the 6 months before to the concerned act. Such person may be associated with the company in any capacity, who occupies the position as a director as defined in clause 34 of section 2 of Companies Act 2013 of the company, or is deemed to be a director of that company, or who occupies the position as an employee or an officer of the company, who holds a position involving a professional or a business relationship, having access to UPSI, or is reasonably expected to allow such access. So section 2, clause 34 of Companies Act defines director as a director appointed to the board of a company.
So here also there is nothing much to add. It is a very simple definition. Yes. That whoever is the person, if he is having an access to the price sensitive information, and because of that his access to the company or to the persons concerned before 6 months to that thing, he will be deemed to be a connected person. And certain rebuttals are also there that we will, there is a deemed concept is there as far as the connected person is concerned. For that, there are certain rebuttals are also can be provided. We will discuss it in the forthcoming slides.
Yes, sir.
Yeah.
So, should the non-executive directors who are not involved in the day-to-day activities be expected to be aware of UPSI then?
See, these non-executive directors, though they are not into the day-to-day operations, but most of the time the non-executive directors, to some extent, they're kept informed what is going to happen. It is not like, so whenever they have some information has been disseminated to them, or by virtue of their position, if they have access to that information, then he will become the insider and he has to handle that information very carefully. So
Because
you
normally,
cannot just say that he is or he is not. It all depends upon the availability of the information to him. Suppose if the company is having, say, 5 independent directors, 3 might not be having the access, 2 might be having the access. Quite possible it is. Because that point of time, the management, because the 2 people who got domain expertise, they might have been consulted while going to take up a project. The other 3 persons who don't have the domain expertise, they might not have been consulted. So 2 people have access to the information, 3 people doesn't have the access to the information. That is how it is to be demarcated.
not only that, by following the due process of the board process, when all the directors are there, especially, you are discussing the profitability of the company and you are discussing about the revenues of the company, result publication of the company and other thing and all in the process. The non-executive directors who are actually there by following the due board process, they come to know the information. So to that extent, they are aware of the UPSA information. When they are aware of the UPSA information, they are governed by it. They cannot just get away. We are non-executive director. We are not governed. That sort of the immunity is not here.
So one pertinent case law to be discussed here is in the case of Deep Industries Limited in 2018. In this case, the directors, their immediate relatives and the persons traded were connected on Facebook and they had liked several photos of each other. So SEBI had held that the definition of connected person provides for the yardstick for insiders by stipulating that insider can be by way of their association in any capacity or by frequent communication with its officers in their social capacity, as is evident in this case, including the likes on social media. So I'd like to understand here, how careful should the connected persons be in their day-to-day activities and how cautious should one be in holding such important designations in companies?
See, that as I told you, as far as the connected persons is concerned, in this particular case, that deemed connection has been established because of that, the relationship, So when you say whether I am connected person or not, when the SEBI investigate that particular matter, they have to went to that extreme of even picking up your social media. I mean, your connects and your contacts on the social media. So one should be very careful that while you are establishing any contacts and all, when this deemed connected person concept comes into picture, how you will insulate yourself, that you should be careful about it.
Right. So let us understand a few other important definitions of immediate relative. Means a spouse of a person and includes parent, sibling, and child of such person or of the spouse with any of whom is either dependent financially on such person or consults such person in taking decisions relating to trading in securities.
See, here also, that it is the responsibility of the compliance officer, because when we talk about immediate relative, it is the immediate relatives of the designated persons. So let me also take this opportunity to give a clarification that it is the responsibility of the company is concerned to regulate the designated persons and their relatives. Regulating the insiders is not the responsibility of the company. It is that the moment any insider make any kind of offense, he will be dealt with by the SEBI itself directly under the regulations. And suppose if somebody, an insider who is not connected to the company, but he got the access to the information and he leaked it, it is not the responsibility of the company to control him or regulate him at all. It is the SEBI will take care of the action under the regulations. But as far as the immediate relatives are concerned, whoever are falling under the definition of immediate relatives, these people are to be regulated by the code of conduct of the company. Sometimes the question has come up by that how their trades will be regulated by the compliance officer, monitored by the compliance officer. So to a large extent, it is by virtue of the PAN number of the people. So whenever you are giving a declaration that who are all your immediate relatives, you have to give their PAN numbers. Recently, somebody asked me a question, and rightly so also, that suppose my brother is my immediate relative and he will not give me his PAN number, what I will do with that? How his trades will be monitored and all those things. I cannot force my brother to give me the PAN number, and I cannot give it. Suppose I am a KMP or I am a director or I am a designated person. And even the compliance officer or the company cannot also force me by hook or crook, whatever it is your responsibility, it is your headache, you have to get the PAN number and give it to us. A reasonable, what's called efforts are to be made to give it. At the same point of time, from the company's point of view also, whenever it comes to his knowledge, the concerned person has to make the disclosures to the company. And similarly, the company also have to ensure that maybe because by virtue of the common addresses or common relationships and all, they may have to make efforts to what's called control this kind of what's called the trading is concerned. Okay.
Yeah, the point is here actually the greater effort is to be taken to ensure that we get the information. As he rightly puts it, even I also come across in sometimes the director very categorically says, my brother is there in Calcutta. I do not know what he's doing, what is the things here. I do not have much of the contact. How can I actually give the information about which I do not know? Those sort of the things really comes to the practice. But the only thing is just reasonable care, what we can take care of it. That's what we can do. As he rightly put it, we cannot force somebody to do the things. That is not possible. Yeah.
And sometimes some relationships are there. So for example, my wife, even if she is financially independent, my children, even if they are financially independent, they might not be consulting me for their financial decisions, but still they will be deemed to be the connected persons, and they have to establish whatever the rebuttals are there, which you are going to discuss in your future slides.
So moving forward, let us understand who's a promoter. Promoter shall have the meaning assigned to it under SEBI ICDR regulations 2009 or any modifications thereof. So what do you mean by securities? It includes equity shares, redeemable non-convertible debentures issued by the company and the interest therein.
So here, let me take this opportunity several times. Go back, Kanchan.
Yes.
So securities, if you see the definition, securities include equity shares, redeemable, non-convertible debentures issued by the company and interest thereon. Several times this question comes that people are under a wrong notion that PIT regulations are not applicable to debentures.
Debt instruments.
So debt securities, if they are listed on the stock exchanges,
yeah,
even if your equity shares are not listed, but still PIT regulations are applicable.
Yeah, it is applicable. It is applicable.
Similarly, even if it is a private limited company, but its debt securities are listed on the stock exchanges, PIT regulations are applicable.
Yeah, that is right. Once you go for the listing, whether it is debt listing or equity listing, it is applicable. Yeah.
So again, some people are under the wrong notion which regulations are applicable. Some people say that only the code of conduct is applicable. So regulation 9 is applicable, regulation 8 is applicable. There is no kind of a demarcation wherever, whichever the regulation gets triggered. Suppose say, for example, because of that unpublished price sensitive information, if there is going to be an impact on the debentures, definitely that is what's called as it is a upsee. And if there is a leakage happens and all, the same way it is equity shares, the debt listing also will be dealt with. And same is the case, you have to close the window, you have to have that contra trade restrictions, all these things are there. Only thing is, instead of equity shares here, there will be the debt listed securities are there. That's it. Okay.
Yes, sir.
Yes, Kanchan.
Yes, sir.
Yeah, before you go there, now I think Ashwini, you may take up the questions in the chat box.
Okay, sir. So there was this question regarding the debt regulations only that we have answered. Rest, I think we have answered. I've checked all the questions.
Okay.
Should I continue, sir?
Yeah, you go ahead.
Okay. So let's come down to regulation 3, communication or procurement of UPSI. An insider shall not communicate, allow, or provide access to any UPSI except in furtherance of legitimate purposes or discharge of legal obligations. No person shall obtain or cause the communication by any insider of UPSI related to company securities listed, proposed to be listed, except for legitimate purposes, performance of duties, or discharge of legal obligations. So legitimate purposes shall form a part of Code of Fair Disclosure and Conduct. A board of directors are to ensure that a structured digital database is maintained. The exceptions to regulation 3 would be that entail an obligation to make an open offer under takeover regulations, and not attract the obligation to make an open offer under takeover regulations. But board of directors is of the opinion that it is in the best interest of the company that information which constitutes UPSI is disseminated to be made generally available at least 2 trading days prior to the proposed transaction.
Yeah, see, the regulation 3 is very clearly, it talks about procurement or communication of OPSI. So this regulation virtually prohibits communication of the unpublished price sensitive information to anyone and everyone. And similarly, it is also prohibits that procurement of the information by inducing the persons. He should not procure any kind of information. However, several times it happens within the organization, the information is bound to be shared, and that's why it says that for the legitimate purpose, the information can be shared. Say, for example, if the subsidiary company is there, it has to share its financial results with the holding company for the purpose of consolidation. So is it allowed or not allowed? It is, because it is for a legitimate purpose. Similarly, the financial, suppose the finance and accounts department has to share the information with the secretarial department, so that secretarial prepares the agenda and other things are there. So within the organization, the information is to be shared, definitely. But certain information need not be shared with everybody. That means need to know basis. That is very, very important. Despite the fact it might be for the legitimate purpose, that doesn't mean you just share the information with everybody and anybody within the organization. No, it is not so. Apart from the legitimacy, you have to also ensure that whenever you are sharing the information, that information is to be shared only on need to know basis. Only give that much what he is supposed to know. Don't give anything beyond that. That is not permitted. So similarly, whenever an unpublished price sensitive information is given to anybody, one thing should be very clear. He should be informed that this information, what I am disclosing to you, and especially in case of the people who are holding fiduciary responsibilities, like auditors, like bankers, merchant bankers, or anybody who is going to connect with that, if you are sharing the information with them, you have to clearly tell them that, look, this information, what I'm sharing with you, this is a price sensitive information. And regulation 3 also advocates that you have to enter into a confidentiality information, non-disclosure information, you have to agreement to, you have to enter into. At the same point of time, that person concerned is to be informed that this information is to be handled only on need to know basis and for legitimate purpose. Suppose, for example, if an auditor, you have given him some information, he is not supposed to discuss that information across the organization, in his own organization. If at all he wants to talk to also, he maybe talk to the concerned partner who is that audit partner or something like that. So information, number one, is not to be shared with anybody and everybody. Information can be shared only for legitimate purpose. And information can be shared only on need to know basis. While sharing the information, do intimate the other person that this is an unpublished price sensitive information. Be careful while handling this, otherwise you will be in trouble. At the same point of time, wherever it is required, also enter into non-disclosure undertakings. Yeah. Add anything to that?
Sudhakar, I just wanted to share a small incidents way back in 94, 95. This company where I was actually employed, they were having a major shareholder from UK. They are holding something about 25% of the shares. Whereas 45% shares were held by the Indian public. Now, at the time of the annual results, I've been told you send a unaudited financial statements to the parent company, which I said, sorry, I will not send it because he is only, as far as concerned, is one of the major shareholders. If I send to the major shareholders the financial statement, I am supposed to send the financial statement to the other shareholders as well. No, they want to know this, that, etc. I told they already designated 2 directors. They are getting the information. If they want, they can share with them. That's all. I'm not going to send it anything officially from me. Sorry. It has created a lot of confusion with our chairman, etc. and other thing and all. It has happened. Because always you will come across such sort of things in these companies. As you rightly say, since you have said, need to know basis. That is what very important is actually concerned. That is why people, whenever they discuss the confidential information, they repeat the particular group, the information is to be within the group. If somebody other than the group is to be shared, it has to be discussed whether to be added to the group or it is to be shared only instantly, only at that particular point of time or something like a limited basis. That's all to be discussed. It is very important to know this concept, need to know basis and work towards it. Yeah.
In fact, let me tell you that also one of my personal experience I can share with the participants is that in one of the organizations where I was working earlier, sometimes my chairman used to discuss certain issues with me as a company secretary and the finance person because I was holding a dual portfolio there, which he was not even discussing with the managing director of the company. That MD, sometimes he comes to know that these 2 people have gone somewhere. And he used to have his own grapevine information. And he used to call me and ask me that where you have been to and for what purpose, with the chairman, where you have been to and for what purpose. There, I have to be very careful. Do I need to disclose that? That is a price sensitive information. And I am not supposed to share with the managing director even. Because when the chairman has not thought fit that person to be intimated about that, who am I to disclose that information to him? So because that point of time, being an educated person and being the compliance officer, it is my responsibility to ensure that unpublished price sensitive information is not supposed to be discussed even with the managing director of the company, because I can do that only on need to know basis. It may be a legitimate purpose, but it is not on need to know basis. So these are the 2 tests I have to make an application before I divulge that information. So he used to get antagonized with me. You don't reveal any information. I said, look, I have my own limitations. But sometimes he used to create some kind of unpleasantness because that nuisance value used to be there for me because always he is the person to whom I used to report.
Agree with you 100%.
That brunt, I left with no option. Sometimes it so happens also. So what I'm trying to say is, as designated persons even, sometimes your friends may say, "Arey yaar, kya chal raha hai, batao tumhara company mein." Several times the company secretaries, consciously or unconsciously, they should not share any information with the friends of them. Because every company, and sometimes they poke you also. Kya chal raha hai tumhara company mein, sab theek thaak hai, what is the expansion plan, diversification, this, that, whatnot, and all those things. Of course, I'm sure that if no one might be doing like that. In the good olden days, yes, it used to happen. But these days, the rigor of the PIT regulations is on the higher side. Nobody can dare to do these kind of things. But still, as a caution, we can always remember the things which we are not supposed to do. Yes,
I
Kanchan.
just want to share my personal experience. This is more not insider and also not communication, means it is an inherently deemed to be a. So please be careful whenever you are dealing with merchant banker or anything, even on a proposal basis, and you conduct these meetings in a conference room in a hotel. Okay, be very careful, especially satellite towns. Say your registered offices in Pune or somewhere and you want to go to do it in Mumbai. Be very careful. All these hotels, some of the guys, they try to choose the duty in these kind of rooms, and they are very clever people. They'll ask you, photocopy kar dun kya sir, ye kar dun kya sir. So coffee outside, lock the room. And in olden days, like what he said, in early 2000, personally I had a situation where I even traced back that person in that famous hotel in Mumbai in order to see what it was, but it was only at the proposal stage. See, I think every nook and corner needs to be closed when you are having this situation. Please be careful if you are having a meeting outside your premises. It is very, very critical that you take the ownership and don't leave it to admin.
Yes, Kanchan, please go ahead.
Yes. So briefly understanding the structured digital database. So the idea of SDD was first generated by the Committee on Fair Market Conduct, and it was later introduced by SEBI Prohibition of Insider Trading Amendment Regulations 2018. So the applicability of the provisions of SDD is on listed companies from effective from 1st of April 2018, which is later extended to all the companies now. It is to be maintained by the board of directors, and the time stamping and audit trails to ensure non-tampering of the database. So we would certainly have a detailed presentation next week on SDD. So this was only introducing the topic.
Just to add, as far as SDD is concerned, this is primarily that, especially off late, the importance of the structural digital database is concerned. Regulators are very, in fact, okay, that ICSI has organized some 2 webinars on this about a month before. I'm sure that several of you might have attended that also. Wherein the regulators from SEBI and stock exchanges were there. They have expressed that some kind of an unpleasantness as far as the compliances with SDD is concerned. That is one of the reasons why we thought that let us discuss this SDD aspect in detail. That's why next webinar is going to be on structural digital database as well as the trading plan. So that point of time we will discuss, but it is more of an audit trail. Whenever there is any kind of leakage of information happens, the regulator wants to know that audit trail from where that the origination of that information and how it flowed by the time it leaked outside. That's what exactly they want to know it from this thing. Whatever the nuances of SDD is concerned, that we will discuss in next week. Yes, Kanchan, go ahead.
Yes, sir. So moving to the next regulation, Regulation 4 talks about trading when in possession of UPSI. So insider is not allowed to trade in securities that are listed or proposed to be listed on a stock exchange when in possession of UPSI. So this regulation provides that when a person who has traded in securities has been in possession of UPSI, his trades would be presumed to have been motivated by the knowledge and awareness of such information in his possession. So what do we mean by proposed to be listed? It shall include the securities of an unlisted company if such unlisted company has filed the offer documents or other documents, as the case may be, with SEBI or stock exchanges or registrar of companies in connection with the listing. It shall also include if such unlisted company is getting listed pursuant to any merger or amalgamation and has filed a copy of such scheme of merger or amalgamation under Companies Act 2013. So could I have the panelists' opinion on this?
Yeah. Here also I say that when you are having UPSI with you, that point of time, you are not supposed to trade. And sometimes it may so happen, you are having unpublished price-sensitive information with you, but your trading is not connected to that, because this is again a deeming provision. Whenever you deal with the securities of the company while in possession of the UPSI, you will be presumed that you have utilized that information. And there are certain leeways have been provided that if you are able to prove that the trading with which you have done with the counterparty is having the same access or same information available with him also, that unpublished price information, both parties are at the same level. That means it is a kind of an interstate transfer. Say, for example, promoters are there. if the promoters are making an interstate transfer among themselves, and both the promoters, because they are part of the same group, so they are having the same information, they are having the access to the same information, provided if they are going to deal in the block deal mechanism. That means they are not doing the retail trading, but they are having some kind of a shares in the block deal, this thing, then they may be able to what's called defend their case. And similarly, any kind of transactions pursuant to, suppose you have made some kind of a trading for whatever this thing and all, in pursuance to some kind of a statutory or regulatory obligations, that point of time also you will not be held responsible under the regulation 4 is concerned.
Yeah, the important point is the unpublished price sensitive information has not been used for the purpose of trading in spite of that information is being available. The genuinity, the establishment will likely give you the leeway. Otherwise, it is not. Yeah.
And similarly, let me also say that in case of suppose the non-individuals, if they are trading, that means the companies are trading this thing. And sometimes it may so happen that the companies which are holding the securities, they are dealing that, they might also be having that access to the information, price sensitive information. That point of time, the companies have to show very clearly the people who have, say, for example, your subsidiary companies. Your subsidiary company got access to the information pertaining to the holding company. Of course, subsidiary company cannot hold the shares and also, for example, take case of associate companies. So, our group companies, you take it. They don't have any relationship, but they are part of your group. In such case, you should be able to prove that the people who are dealing in the market and the people who are dealing in the operations, who got that access to the information, there are complete Chinese walls or firewalls are there. They don't share the information at all. If you are able to prove it, then you may be absolved. Otherwise, it will be a deeming provision. You have dealt with the securities of the company while in possession of the UPSI is concerned. Yeah.
So there are certain exceptions to Regulation 4.1, like we've already discussed. So off-market interstate transfer between insiders without breaching Regulation 3. Transactions carried out through block deal window mechanism between persons who are in possession of UPSI without being in breach of Regulation 3. A bona fide transaction pursuant to statutory or a regulatory obligation. Transactions undertaken pursuant to the exercise of stock options. And trades pursuant to a trading plan set up in accordance with Regulation 5. And in case of non-individual insiders, those individuals in possession of UPSI differ from individuals taking trading decisions. And when they took such decision, they were not in possession of such UPSI. And appropriate and adequate measures were in place to ensure that regulations were not violated. So moving on to Regulation 4.2, it provides that in case of connected persons, the onus of establishing that they were not in possession of UPSI shall be on them. And in other cases, the onus would be on the board. Regulation 4.3, it empowers the board to specify such standards and requirements from time to time as it may deem necessary for the purpose of PIT regulations. So here I would like to briefly understand from our panelists, what measures can the board adopt to be compliant with the regulation?
With regard to what this is?
Regulation 4.2. So the board needs to take certain measures to comply with these regulations. So how can the board take any kind of measures? If we could briefly throw some light on Regulation 4.2 and 4.3.
By putting restrictions, as far as the sharing of the information is concerned, they should put adequate restrictions and ensure that the same are complied with. And similarly, as I told you, that these are the only thing that suppose when the information is there, for example, provides that in case of connected persons, okay, they were not in possession of the UPSI. So that no doubt about it, that it will be presumed that the connected persons did the trading based on the UPSI. And the onus is on them to prove it. That means that rebuttals, wherever they are there, that they have to do that. they are not having the information. Number one, if at all they're having the information also, they have not used that information for the purpose of trading.
The board has to actually put up very
Then it
clearly
is
to
the
the correct.
onus is on the SEBI to prove that, yes, you have dealt with based on that information.
See, whenever you are having a connected person, the board has to ensure, okay, you are actually connected for this particular purposes. These are all the things which are there, and these are all the code you have to actually follow. This information should not be actually shared unless until it is a need base or within the group, etc. All these things has to be made known to the person, and he has to see that the person adhere to it. Even many times we undertake the undertaking signed duly from connected people also, that during such period that information will not be shared by him, etc. And also even the duly writing is also taken many times.
So this is briefly to understand the policy for fair disclosure mentioned in Schedule A. It calls for prompt public disclosure of UPSI that would impact price discovery. Ensure no UPSI is disclosed to analysts and research personnel. Ensure the transcripts or records of meeting. Appropriate and fair response to queries on news report and requests for verification of market rumors if needed by public authority. Prompt dissemination of UPSI that gets disclosed partially. And CIRO, Chief Information Investor Relations Officer, to deal with disclosure of information. And uniform and universe dissemination of UPSI, thereby avoiding the selective disclosures.
See, primarily this particular fair disclosure code is to be prepared because, as we have discussed in Regulation 3, wherein it said that the information is to be shared for legitimate purpose. So, what is the legitimate purpose? That it is the board have to lay down a policy and stating that for the purpose, for these are the legitimate purposes under which the information can be shared. So that's why under Regulation 8, a fair disclosure policy is to be what's called as prepared and to be approved by the board. In that, you have to say by that where the information can be shared, what is the legitimate purpose and all. To a large extent, legitimate purpose includes like sharing of the information in the ordinary course of business by the insider with the partners, auditors, bankers, and maybe sometimes with the what's called as with the dealers of the company and so on, advisors, consultants, so on and so forth. But this information, as I told you again, the same thing that I mean, for not only for the legitimate purpose, but on need to know basis. Yeah.
One more thing is there, as you put it here, secondly, that sharing the information with the analyst on the research, there one has to be very, very careful, because what happens is many times the analysts and the research, they are all actually in the way in which they put up the question, etc. That means we are trying to get the more information. Unknowingly, there is a possibility of disclosing the sensitive information to them. That possibility one has to take very care, because I have come across some cases like that. So really speaking, one has to be very, very careful when we are dealing with the analyst, because what happens is once the information is given to the analyst, it actually goes to the public, they bring the analytical report, etc. and other thing, it comes in. So one has to be very careful in dealing with this aspect. Yeah.
So penalty for provision violations of the regulations by SEBI. So SEBI may issue the following directions to the violators, directing the insider not to deal in securities in any particular manner, by prohibiting the insider, by declaring the transaction or transactions in securities as null and void, and restraining the insider to communicate or counsel any person to deal in securities, directing the person who acquired the securities in violation of these regulations to deliver the securities back to the seller. So Section 24 of the SEBI Act 1992 provides for offences as under If any person contravenes or attempts to contravene or abets the contravention of the provisions of this act or of any regulations or rules made thereunder, shall be punishable with an imprisonment of 2 years or more, or with fine of 25 crores or more, or both. And if any person fails to pay the penalty imposed by the adjudicating officer, he shall be punishable with an imprisonment ranging from 1 month to 3 years, or with fine of 25 crores or more, or both. Some of the landmark case laws pertaining to Regulation 3 and Regulation 4. In the case of Shruti Vora, Neeraj Agarwal, Parthiv Dalal, and Aditya Gaggar versus SEBI. So the judgment came as forwarded as received WhatsApp message circulated on a group regarding financial results of a company, closely matching with the vital statistics, would not amount to a UPSI under the provisions of SEBI PIT regulations.
But only thing I would like to caution is that these case laws, whichever are there, they're all case-to-case basis. It can be taken only as an indication, but not as a what's called as a rule or something, as a law, something like that. One need to be very careful, even on the WhatsApp messages or messages on the social media. Let me also say one more thing also. When we say that when the information is published, it will be coming in the public domain. And publishing the information in the social media does not amount to the information is coming in the public domain. Publishing the information only with the stock exchanges, it amounts to coming on the public domain. Once it comes on the public domain, it will no more remain as obscene. That's why what is publishing the information is also equally important to understand that.
Right.
In this particular case, like the WhatsApp case, what you are saying, actually, some or other, the regulator could not get into the bottom of it. They could not trace it. It is actually emanated from where, what is the root cause. That is the reason probably it has got actually. If they would have actually found out the person from whom it has actually leaked out, the things would have been different. Yeah.
Yes, sir. So in another case law, Hindustan Liver Limited versus SEBI, the judgment was given by the SAT, stated that the presence of directors who were common to both HLL and BBLIL, as well as common parent company in Unilever, indicated that they were effectively managed together. As a result, HLL could be classified as an insider under the regulations, and it was reasonable to assume that HLL was privy to the BBLIL board's decision making on the merger issue. So in the case of PVR Limited versus SEBI, SEBI has imposed a fine of 2 lakh rupees each on Gautam Datta, who's the CEO operations of PVR Limited, Mr. NC Gupta, Company Secretary of PVR Limited, and Pramod Arora, Chief Development Officer of PVR Limited, for violation of rules and regulations regarding insider trading. A fine is also imposed as part of violating disclosure norms, which makes it mandatory for a related person to inform the company about their share trade. So that's the end of my presentation, sir.
Okay, there are some interesting questions are there in the chat box. Go through this. One of the questions, I have 2-3 questions I found interesting. I will answer that. After that, you may take up. One is that a listed company passed a resolution to issue the sweat equity to the promoter and managing director of the company. In principle approval received, should this company allot the shares whenever the trading window is closed? The trading window restrictions are relaxed only for stock options, not for anything else. So that's why this particular case, where it is sweat equity shares, it is better to avoid, according to me, not to be allotted during the window closure is concerned. And similarly, in case of invocation of pledge, would it be termed as trading by the borrower or by the lender, because the invocation of pledge carried out against the will of the borrower? It is whether it is a question of the will of the borrower or not. Trading, if you see the definition of the trading, it is all types of pledges. That means pledge, invocation or revocation, they are covered in that. So if both the companies are listed, it will amount to the dealing in the shares of the company, and the necessary compliances are to be made. Even in case of an invocation of the pledge also, it is not like that without intimating to the borrower, the lender will invoke the pledge. Definitely he will intimate to him. So necessary compliances are to be made from both ends. And one more question is that in case of a KMP, can he purchase the shares of the company at the time of IPO of the company through SBA process? Has this KMP has to be pre-intimated to the company compliance officer, blah, 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 blah. See, if you see again the same thing, if you see the trading definition, it mentioned that subscription of the shares also amounts to trading, whether it is a public issue, whether it is a rights issue, private placement, preferential allotment, whatever it may be. Except the stock options. In all the other cases, whenever you are subscribing to the shares or securities of the company, and you are having some unpublished price sensitive information with you, then you are not supposed to do that. Because that, based on that, say for example, even in case of an IPO also, whatever the information is disclosed in the prospectus was up to a particular point of time. Subsequent to that, whatever the information which is available with that particular KMP, which is not in the public domain, and that is going to impact the price, maybe post IPO also. In such case, if that particular, if the KMP is not supposed to subscribe to the shares of the IPO, that is what I view it. Otherwise, tomorrow, if say, for example, if the moment the IPO is there, he is subscribing it and then he is dumping the shares in the market immediately on the day one. Based on that, he will be held responsible for that. Yeah, Ashwini, any more? Because these are some 2-3 questions I could just take a note of, and other things, if anything is there, you may take up.
Yes, sir. When a company secretary resigns and is serving notice period of 90 days, when should the trading window be closed? And how does resignation of CS impact share price of a company?
See, you cannot say whether the resignation of a company secretary impacts or not impact and all those things. But definitely, the moment the company secretary is resigning, and you have to intimate under Regulation 30 to the stock exchanges. So there won't be much of a time in between that the information becomes sensitive or information is published. Normally, if it is resigned, it is going to be intimated to the stock exchange immediately.
Okay, sir. That's the only question now.
Also, the question was how the resignation of CS will affect price.
It may depend. Why not? Say, for example, sometimes the CFO of a company is resigning. And sometimes, say, for example, there is a conflict between the promoters. And some kind of a news reports are there in the market, but much information is not there. And all of a sudden, the company secretary resigned. So sometimes the regulator is initiating an action and there is a news report about that and the company secretary resigned. So people may expect that something is wrong with the company, and that's why suppose CFO and CS simultaneously resigned, or CFO or CEO and the company secretary resigned. These kind of things may happen. In the normal circumstances, when a company secretary resigns, it may not cause any impact on the share price. But if there are some kind of a news reports about the company of the wrong things especially, and in such case, if the CFO or the CEO or the company secretary resigns, it may impact. That may be price sensitive information.
Yeah, it happens to case to case.
We cannot generalize it. It all depends upon the situation to situation, case to case basis.
You are absolutely right, Sudhakar, because in many times we actually come across what happens is suddenly CEO resigns, followed by it immediately CFO resigns. Because as you rightly say, there is something wrong. The natural consequences happen CEO and CFO because of the various issues. So as you rightly say, unless until we know what exactly the case, I think we cannot generalize this sort of a thing. In the normal courses, if the person changes the job and resign, yes, it is not. Otherwise, if there is something about the company news, etc., and other thing, it will depend upon the case to case basis.
Correct.
So I think the questions are over.
Yeah, I think all other things you already discussed. I don't see there is anything apart from this unless participants have something more. Otherwise, no questions are actually pending for to be answered.
Yeah, I think so. everything is
Just
answered.
one point I wanted to make, if I may come in.
Yes, please.
As per the
Karthik, good to see you.
thank you, sir. Thank you, Dipti ji and everyone, Professor Bala and all. See, as per the definition of UPSI, changes in KMP is also UPSI. Please note that. You can see the PIT regulation itself in the definition section. It is given. If you see the definition section, one of the
Yeah, see that Karthik, I appreciate what you say. The question is not about whether it is UPSI or not. Question is about window closure. To that, my answer is the moment there is a resignation of the company secretary is concerned, you are obligated under Regulation 30 to intimate the exchanges. So the moment the information is generated and the information is published, it will be very, a few hours or few days may be the difference. Not even days actually. So till the time, if you think that the company secretary has submitted his resignation and the resignation is not accepted, not intimated to the stock exchanges, then it is, okay, it will go into a different proportion altogether. So I am answering that about the window closure is concerned.
got it. I got
Number of times that gap will be very, very thin.
it.
So you don't need to close a window technically.
Not required. I agree.
I
But it
think
is certainly a price sensitive event, I'm saying.
Yeah.
Correct.
You're right. You're absolutely right.
I think we have answered all questions, right? We can close it.
Only one thing, Dipti, I want to add here is that sometimes it is a very tricky situation even for the company secretary. Suppose the company secretary may say, look, I want to close the window. The CFO may not agree to that. He's saying, yeah, for everything you want to close the window, what the nonsense it is. So, but it is the responsibility of the company secretary to determine what is price sensitive information and where window is to be closed. And it is his responsibility to convince his superiors to a large extent. And God forbids, if at all still they are not convinced at all, you should have a necessary backup with you to insulate yourself tomorrow.
Yeah. Sudhakar, there is one more question about closure of window during interim dividend.
What is that?
Recent chat box. There is a
What
question.
about the closing the trading window while declaring the interim dividend?
Yeah. See, if you are going to declare an interim dividend, you may close the window because it is going to be, definitely it is a price sensitive information. So for example, sometimes the companies may come with a silver jubilee dividend, special dividend. They may be coming with some kind of this thing. So if that is the case, see, but what I'm trying to say there also is what happens is the moment there is that information generated and by the time it comes, if there is a what's called as a time gap is there, yes. Sometimes it may so happen that this kind of declaration may happen at the time board meeting itself. The company secretary may not even have the time to close the window because by the time the decision has taken, the decision is intimated to the exchanges, there may not be a time gap even. Okay. Say for example, the board meeting is going on and therefore there is a supplementary agenda kind of thing is placed. And they say, okay, let us come with an interim dividend. If that is the case, yes. But suppose if there is the board is consciously deciding that, yes, let us come to an interim dividend, let us examine the availability of funds, blah, 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 and all those things. Then yes, no doubt about it, it is a window is to be closed. So we cannot generalize where you have to close, where you are not to close. It depends upon case to case basis and the nature of that information.
Okay, thank you. I think that's and our all answers to the questions, and we can close this session.
Yeah, only thing is that next week we are going to have one structural digital database and trading plan, and the participants may be requested to, they may come prepared so that we can have fruitful discussion on that.
Yeah, we like all participants to be more participative, ask questions, share the experience. It's not one way. Please don't make it one way. Please share your experience.
Even participants can send the queries also in advance if they want to have.
Yeah.
Absolutely.
Okay. Thanks.
Thank you very much. God bless.
Thanks, Lord Sudhakar. Thanks, Mr. Bala. Thank you. Thank you, Kanchan, for good presentation.
Good presentation. Keep it up.
You've done a wonderful presentation. And one more thing is there, above all, I must congratulate everybody. You are maintaining the timing today. We are 10 minutes to go. So thanks a lot.
Thank you. Thank you, everyone. Thank you.